Okay, we are on the record. And good morning. Today is October the 16th, 2025. I'm Sharon Bernardi, and I'm joined by my fellow board members, Mr. Fred Lauer and Ms. Deborah Dobkin. And this is a public deliberation being convened at 9:30 a.m. by the Baltimore County Board of Appeals in the matter of 19A Newport Drive, LLC, legal owner Evans Funeral Chapel. And it's case number 24-076-SPH for property located at 11543 Philadelphia Road in the 11th Election District, 5th Council District in Baltimore County. And this is a public deliberation to consider protestants' motion for reconsideration. And the basis for that motion was enumerated in several arguments that he is presenting to us, and just want to summarize a few. One is he notes that there's Maryland case law upholding the right of a vested interest to maintain its zoning after a comprehensive rezoning process, but he contends that none of the existing cases deal with special exemption rights for which an extension of time was granted. And so he believes that there should be a reassessment of that argument. He also says the property in question is severely flawed because the rear of the property is in a floodplain with a ravine running through it, limiting the use of the land. He also references limited parking spaces and no overflow parking that puts pedestrians in danger. He references the 2-year limit for the special exemption had run out because the county was exercising its due diligence, and that ALJ Mayhew had serious reservations about extending the time, and so he believes that there should be a deeper dive into the county's process before making this determination for the use of the property as a funeral home. He also says that the establishment having a proposed crematorium is incompatible with the community, and he presents what she says is new evidence that there's a playground that was recently, I guess, dedicated. There was a ribbon cutting, and that was information that wasn't available to us before. He also says that the CZMP 2023-24 process, that the property was placed under review during that process, and the county council deliberated that and concluded as a matter of law that the site requires rezoning to align with the neighborhood's evolution. And so he was requesting that the county's comprehensive map process has inconsistencies, especially regarding the vesting of the plan, and that there was no community input meeting because there was no knowledge of the crematoriums. Those were, I think, the primary arguments he was making for his motion for reconsideration. And in response to his motion, the petitioner references in our Board Rules of Practice and Procedure 12A that the motion shall state with specificity the grounds and reasons for the motion, including but not limited to newly discovered evidence, change in law, and or fraud, mistake, or irregularity. And he says that the protestant, Mr. Dudek, previously articulated these issues before the board, and he doesn't believe that there is any new factual information. I should quote, he says that a motion for reconsideration is properly considered only when, and this is per Calvert County v. Holland Realty, that some new or different factual situation exists that justifies a different conclusion. And he argues that Mr. Dudek has failed to meet that standard set forth in Howland Realty. And I was going to give my position, wanted to make certain that I stated what you believe are the primary arguments that he raised in his motion and the petitioner's response before I share my thoughts on the motion.
I agree.
Okay.
Okay.
Thank you. So I believe that these arguments were raised previously. That I don't recall that there was testimony from Ms. Perkins or anyone regarding the school playground. And please refresh my memory if I'm incorrect there. But given that information, I still believe that that was evidence that would have been available at the time of the hearing that we held, because the ribbon cutting took place so soon after our hearing. And that being so, I didn't believe that that's newly discovered evidence. It may not have been presented to us, but I don't think it's newly discovered. So I wouldn't grant the motion for reconsideration, because I believe all the arguments were made previously, and I didn't see any new evidence that would give us cause to convene a hearing.
I agree.
I agree also. I don't think there's sufficient grounds for reconsideration based on the evidence that we have before us.
Just as the Mr. Dudek asks us to review the law, that's really a legislative function. We don't have authority to do that. And for better or for worse, the code does provide for the zoning in effect to prior to the change in the maps to invest it under certain circumstances. Invested is the wrong word. The language in the code is pretty clear that it would be applied. So I don't think it's within our wheelhouse to change the law.
I agree with you, Ms. Dobkin, as well.
Me also.
Thank you, Mr. Lauer. Well, I didn't have any other issues that I thought we needed to deliberate on. I believe we thoroughly identified them and have made our determination regarding them.
So I think we're unanimous in denying the motion.
Thank you, and we will issue that decision, and thank you both. Much
Thank
appreciated.
you.
Okay. Go
Have
for
a
it.
good day.
You too. Thank you.
So long. Thank you.